All persons having business before the Honorable Chief Judge and Associate Judges now presiding over District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order. All persons having business before the Honorable.
All right, good morning, everyone, and welcome to the District of Columbia Court of Appeals virtual oral arguments. We apologize for the delayed start this morning. We were experiencing some technical issues as we are learning to deal with as expeditiously as we can in this virtual environment. I appreciate the patience of the parties in this first case. Now, I noted that we have Judge Phyllis Thompson, and we also have Senior Judge John Farron, who was participating by audio only. But it appears that Judge Farron may have been dropped from the audio feed. He was with us just a moment ago. Do we need to have him try to dial back in? Mr. Green? From the audio feed.
Okay, I could check.
He was with us just a moment ago.
Yes.
Do we need to have him try to dial back in?
Yes.
All right. I with apologies to counsel, I'm going to ask if we can stop the recording so we can make sure we have all three judges present. Mr. Green,
Yes.
you would, and then we can begin again in just a moment. Apologies to counsel. I'm going to ask. Okay, so.
Are we indeed live? It looks like we are.
Okay, so.
Are we indeed live? It looks like we are.
And then we can begin again in just a moment. Apologies to counsel.
Are we indeed live? It looks like we are.
And then we can begin again in just a moment. Apologies to counsel.
Are we? Are we indeed live? It looks like we are.
And then we can begin again.
Okay, judges, we are live.
Mr. Green, I'm hearing feedback in the background. Are others hearing that?
Yes.
I heard it also.
Good morning, everyone. Again, I apologize for some of the technical difficulties we've been experiencing this morning with our oral arguments.
Okay, we're good.
There seems to be a delay in the recording of the audio. We're going to move forward as best we can. I'm joined this morning on the panel by Judge Thompson. Senior Judge John Farron is a member of the panel and was with us earlier, but is experiencing some technical issues. So he will have to take the arguments on tape. Our first of three cases this morning, we'll go ahead and begin with. This is in the case of Johnson versus U.S. Are the parties ready to proceed?
Yes, Your Honor. Good morning, Your Honors. James Whitehead on behalf of Appellant James Johnson. I'd like to reserve 2 minutes for rebuttal, if I may. In this case, Kayla Harris burst into Mr. Johnson's back door, lobbed obscenities, and in her own words, kirked out on him. In response, Mr. Johnson demanded that she leave the premises. However, Kayla Harris refused to do so. Mr. Johnson said, in trying to get her to leave, and this is the sanitized version, you better get your daughter, make her leave. If you don't make her leave, I'm going to make her leave. I'm going to wipe her out. On this record, the government failed to prove beyond a reasonable doubt that Mr. Johnson did not act in defense of his property when he issued this mere threat of force.
Can I interrupt for a moment, Mr. Whitehead, and just ask you, and the reason for my question is that when you gave us the sanitized version of the language, you said something like, you better get your daughter out of here. And so you seem to be describing the utterance or referring to the utterance that occurred when the defendant and Vanessa and Kayla were all in or around the laundry room. Is that correct? Because there were three separate utterances, it seems to me, in this case where similar language was used. There was the instance when it was Kayla and Mr. Johnson alone, when Vanessa was elsewhere. There was when Mr. Johnson and Vanessa were walking down the alley and Kayla was in her car and she heard the utterance. And then there was the incident, the third incident in the laundry room. Are you focusing on the third one? And is that what you think the trial court was focusing on in finding Mr. Johnson guilty?
So I'd actually think that there are four instances. The first is, the court's correct. This is within the house. Vanessa's not there. And Mr. Johnson says, your mother doesn't even want you here anyway. I'll have her put you out. F all y'all. And then there's an instance when they're on the way back, they meaning Vanessa and Mr. Johnson, they're about 20 feet away, and Kayla overhears, if you don't make her leave, I'm gonna make her leave. And then when this is what Kayla says that he's approaching with the box cutter, he also says to Vanessa, this is the point where if you don't make your MFing daughter leave, I'm gonna make her leave, I'm gonna wipe her out. There's actually a subsequent time where he addresses Kayla Harris, and that's in the laundry room when she has her foot wedged in the door and won't leave. And he once again says very similar, if not the exact same thing, you better make her leave. If you don't make her leave, I'll make her leave. I'm gonna wipe her out. And I think the court was focused on this third instance, which was actually outside of in the driveway on the premises, as Mr.
What makes you think that? The court did say something about Mr. Johnson being about 5 feet away. Was the testimony that during the incident you're focusing on, he was about 5 feet away?
Right. So at the moment when he's approaching, Vanessa and Mr. Johnson are both outside. They're coming from wherever Vanessa had been. They're approaching the back of the house. That's at the time where Kayla is in the car with the children and presumably with the dog. And she overhears, Mr. Johnson doesn't address Kayla at all. So he's telling Vanessa, better make her leave or I'm gonna make her leave. That's right. About 20 feet away. And then at about 5 feet away.
Doesn't that undercut the whole notion of trespass? That he doesn't feel like he has the ability to ask her to leave? Doesn't that undercut the whole she's on the premises without permission argument that is necessary for the elements of trespass?
No, not at all. He actually, I think the interpretation, and the only reasonable interpretation, is that he is authorized to kick her out or eject her, and the government concedes that he has authorization and that he knows he does. It's just that Kayla won't respect him. It's a matter of he's telling her, they have this relationship already. She already bursts into the house and is cussing him out. And he's saying, well, your mother doesn't want you here anyway. I'm going to have your mother put you out. The mother is just the method. She's the means of trying to extract her without a terrible, volatile situation.
Mr. Whitehead, what I'm having trouble with this argument here is, what is he really protecting? I mean, was he protecting the dog? Was he protecting the house? I mean, this defense of protection of property, I know you have to sort of get over the initial hurdle of the trespass, but this is a family. She's been in and out of this house many times before, never been, as far as we know, viewed as trespassing. She's there to pick up her nephew or her sister's child. It just doesn't really seem like it fits this situation. Defense of what? I mean, was he really defending his home from his
Yeah,
girlfriend's
yes.
daughter because she was going to do what to his house? I mean, don't we really need more context or a different context for this defense of property? What property was she destroying or injuring or harming? I'm just having trouble with. It seems like we're sort of trying to jam a square peg into a round hole to make this particular defense apply to a situation like this.
Well, he's protecting his home, and this court has
From what?
adopted
From what? I mean,
from a trespasser, from an unwanted intruder, and
a
we could look
family
at.
member who's been there many times before, I would argue. They
Well,
don't
that
like
doesn't.
each other. They don't get along. But she was there like she comes regularly. And we can assume or infer from this record and the fact that, she's picking up her sister's kid. She's parked in the driveway. I just think this is a bit of a stretch to make this particular defense fit. The piece about the metal spoon that she gets out of the car is even more perplexing. Like, is she really going to harm his property with the spoon? And this defense is a valid defense, and a legal defense under certain circumstances, but these circumstances, I guess I need a little more persuasion as to why they fit this situation.
Sure. I mean, I think history tells us that sometimes the most volatile relationships and the most toxic are domestic ones, or those that are, involve either blood or, in this case, Miss Harris is not Mr. Johnson's daughter, but effectively, I guess you could consider some type of stepdaughter of some sort. But that doesn't mean that the record shows that she was either invited or that she could not be ejected just purely because she was some type of family member.
Mr. Whitehead, I apologize for interrupting, but now it looks like we've lost the government counsel from the connect. Okay, he's back there. Mr. Saybolt, are you with us?
At least we have a.
Okay, I
Great
apologize.
photo of him.
Mr.
He's
Whitehead.
muted in any event, so.
Yeah, okay. It looks like we lost your connection for a moment. Can you hear us okay?
I can. I missed part of your talking to Mr. Whitehead about the trespassing element, I think. So, but I think the court was saying.
I just briefly reiterate that I was sharing some skepticism about why this defense of property defense, which is a lawful defense, fits these particular circumstances where the daughter of Mr. Johnson's girlfriend had been to the home many times before. And Mr. Whitehead was responding to offer further persuasion. Thank you, Mr. Whitehead.
Sure. And somewhat. In terms of Kayla Harris, she doesn't have lawful authority over the property. She's not a lawful occupant. The government didn't argue that below. They don't argue that here. So she is in all intents and purposes, she's a stranger. To the extent
I think they did argue that she had implied permission to be there. Did they not?
She's testified, and this is very ambiguous testimony. She said that she had been there earlier, and she didn't give any further context to when that earlier was, whether it was earlier in the day or earlier in the week or what have you. So she did imply that she had some type of permission, but she didn't have a key. The government never stressed and said that she is a lawful occupant in the way that she could command over the home in the way that Mr. Johnson or that Miss Vanessa Harris could. I mean, certainly.
Could I just interrupt you? Because I want to go back and try to nail down why you think the incident that the court was relying on in finding Mr. Johnson guilty was what you call the third one, which was after Mr. Johnson and Vanessa were walking down the alley and he uttered something, and then he approached the house and I guess was close to Kayla and said something again. Why do you think that's the incident? Because for some reason, and perhaps I'm wrong, for some reason, I thought the court was focusing on what you would say is the fourth incident.
And that's fine. I think that.
Well, I think it makes a difference though, because for example, I was thinking there were three incidents. And as to the second one, what occurred to me is that while there is a point where Kayla says her car was in the driveway, at a couple of other points, she says she was parked in the alley. So if she heard an utterance in the alley, it seems to me there is an issue of whether she was even on the property. So it kind of makes a difference whether the court was focusing on the alley utterance, I'll call it. If the court was focusing on what I was calling the third incident, the laundry room incident, the testimony was that she was in an altercation with Vanessa. They were arguing. You know, if you're going to engage somebody in argument, it seems to me there is an implied right to be there to continue the argument until the person says, leave, get out of my house. And the description there was that Kayla and Vanessa were arguing, still arguing, when the defendant uttered what he uttered. But Vanessa had not at that point asked her to leave. So it seems to me it makes a difference to the outcome. You're focusing on what you call the third incident. So I'm trying to understand what was happening then in order to understand whether this arguably was an instance of him defending his property. So go from there.
Okay,
Please.
so
Tell me why that's the incident.
So I'll try to clarify a little bit more.
Mr. Whitehead, and again,
we've lost
we keep
Mr.
running into
Sable.
this issue. We've lost government counsel again, and I think this some of the technological glitches we've experienced are impacting several aspects of this argument. So I'd like to give him a moment to try to log back in. That way we don't have to repeat. And of course, we'll add on the missing time for you. Mr. Sable, are you back with us? Can you hear us okay now, Mr. Sable?
I am. I'm trying to move, Your Honor, so to avoid it. I can, Your Honor. I missed a lot of what Judge Thompson said, but I'll be okay.
Let me give you the 10-second version. So my question was, it seems to me it makes a difference which of the incidents was the basis for the guilty verdict. So I was asking Mr. Whitehead to tell me why he thinks it's the incident that he sort of described as the third one.
Okay, great. So we have Mr. Sable back. And so just to try to give a little bit more context here. So Mr. Johnson, as he approaches with Miss Vanessa Harris, says, if you don't make her leave, I'm going to make her leave. And then this is in the driveway. So we know it's in the driveway and on the premises because Kayla says that she's about 4 or 5 steps from the back door, from where she retrieves the spoon. From the car is 4 or 5 steps. So this is, and she says that she's in the driveway and that's where the car is parked. And so as they approach, once Miss Kayla gets the spoon, she testifies that Vanessa is telling her to leave. She's trying to get Kayla to leave, and I'll look for specific page numbers for that, but she's trying to get her to leave at that point. And that Kayla follows. At this point, Mr. Johnson has actually gone into the house. Kayla testifies that she doesn't know where he had gone, but he goes into the house and Vanessa goes into the house as well. Kayla follows Vanessa to the home, and that's where Vanessa is actively pushing on the door to try to get Kayla to leave the premises. And Kayla testifies that my mother's trying to get me to leave. She was asking me to leave. This is on page 59 of the July 9th transcript. And Kayla was refusing to do so. And it was only when Kayla kind of on her own volition removed her foot. And this is after Mr. Johnson once again had addressed Kayla and said, you know, if you don't get her out of here, I'm going to make her leave. I'm going to wipe her out. And so he actually makes these two very similar statements. One is within the house, and then the other was moments before, where they were still outside of the house. He has the box cutter and she grabs the spoon, and this is in the driveway. So I think that while there are some distinctions, either way, there's the defensive property defense not only applies, but the government can't prove beyond a reasonable doubt that he was not defending his property. In terms of outside, when he initially says, I'll wipe her out if she doesn't leave, or Vanessa doesn't get her to leave. And inside, when that incident where he tells Kayla that I'm gonna wipe you out, that really sparks things up, and Kayla really becomes even more belligerent than she had been. That's when she grabs the spoon.
Mr. Whitehead, the timing of when she grabs the spoon is of interest to me, because she's first threatened by Mr. Johnson, both inside and then again, if I'm reading the record correctly, in your brief, pages 20 to 21, I believe, he threatens her with the box cut.
Right, immediately before.
And it's not until after that she grabs the spoon. So how does that impact on this defensive property threat, as opposed to just making it a threat to her?
Well, I was just trying to contextualize things for Judge Thompson in terms of the incident outside of the home in the driveway versus what occurred in the laundry room, where Mr. Johnson said, once again, you know, I'll wipe her out if you don't get her out of here. I think if anything, it just shows that Kayla, it was ineffective in terms of his threat of force. But to return back to Judge Blackburn-Rigsby, your question about 10 minutes ago about what was he protecting? I mean, he has the absolute right to protect his home, in the same way that Ms. Jones, in this court's case, Jones versus U.S., that Ms. Jones was protecting her home from a trespasser when the complaining witness had put his feet on her home, which was a cardboard box in that case, and that she was entitled to use reasonable force in that case, use the lighter to singe his socks and kind of give him a threat.
Yeah, but what seems to distinguish Jones from this situation is the fact that Mr. Johnson had the steel-bladed box cutter that he was threatening Kayla with before she pulls out a spoon or anything else. I mean, that to me is a distinguishing factor from Jones, where she's protecting her space that was her home.
Well, and in terms of, if we think about this is part of whether it's a reasonable force that's being used, I mean, I think here we still have a threat of force. And the government, I think we talked about in our reply brief how they conflate the threat of force with the use of deadly force or the use of a deadly weapon. And that's not what we have here. This court has said as much in Jones that in evaluating whether excessive force was used in defense of person or property, we do not equate the mere threat of physical injury, even with a deadly implement, with the actual infliction thereof. And we also cite Yancey, which is cited by Jones, which is the case about an individual grabbing a hold of Mr. Yancey's saddle and refusing to let go. And Mr. Yancey pulls out a knife within 5 feet, says, if you don't turn my saddle loose, I'm gonna cut you loose. And that is something that was cited by this court. It's something that it's extremely analogous to what we have going on here. So the court never says that he was using the knife in a way that was assaultive behavior. And there's never a finding that he was assaulting Miss Kayla Harris with this knife in terms of swinging it at her or anything. He was approaching and displayed a knife or a box cutter, I'm sorry, and was issuing a mere threat. And that's what he was charged with, the attempted threats. And this court has said in Jones, repeatedly, that a threat with a deadly implement is not equivalent to actually using, or the proverbial pulling of the trigger, which would be different than just displaying a firearm, which is what the Jones cites, and also even the government talks about that. So in terms of reasonableness, it really can't get any more reasonable or lesser or minimal the amount of force that was used by Mr. Johnson here in terms of a mere threat. And we know that he under the situation, he could have used more to eject a trespasser, but he never laid hands on her. He didn't cause her any physical harm. And we know that the threat itself did not even work because, in fact, she grabbed her spoon and then charged up to the home. So he certainly has a right to eject a trespasser, to go back and
and not to be a broken record, Mr. Whitehead, I apologize, but did you finish answering my question as to why you think the piece of this that the court was focusing on was what was happening when she first grabbed the spoon?
I think that there were these two, for the way I see it, that there were these two incidents, and the court.
Well, I had thought there were four. Now we're down to two.
No, I meant two incidents of a threat being used. One was where he's approaching with the box cutter and says, this is outside in the driveway, where he says, "Get your MFing daughter to leave. If you don't, I'm gonna make her leave. I'm gonna cut her loose, or I'm gonna wipe her out." And then the second was when, after the spoon, she pulls out the spoon and they go in the house, and then she refers to, then he refers to very similar language while they're trying to push her out the door. Now, the court doesn't refer to either one of these, and I'll double check on rebuttal. And I think that we are arguing that under either, if the court was looking at either incident as the attempted threat, that it doesn't change the outcome, which is there was insufficient evidence that the government showed that under either scenario, that he was not defending his property beyond a reasonable doubt. I'm not sure if that quite answers the question. I think.
Well, it's helpful. I'll go back and look at the transcript, and I'll be interested in what Mr. Sable thinks was the basis of the guilty verdict too. So thank you.
Mr. Whitehead, we're going to move to hear an argument from the government, Mr. Sable, and I know you've reserved your time for rebuttal, so we'll return to you shortly. Mr. Sable?
Thank you, Your Honors. Good morning. David Sable on behalf of the United States. In response to Judge Blackburn-Rigsby's question about what is he protecting, I think it's important to note that the trial court, after specifically reviewing the elements of the defense and specifically citing Gatlin, said, and finding that the government had proven beyond a reasonable doubt that the defense was not available, that the defendant wasn't acting in defense of property, said there's no evidence the defendant is acting in defense of property. No evidence. And I take that as a finding that, particularly with respect to his reason for acting, was that he was not acting to defend his property. He wasn't concerned about his property. He was simply concerned about
We're not hearing you, Mr.
embarrassment.
Sable.
Rigsby, you focused on. Can you hear me now?
Yes,
Yes.
you were saying he wasn't concerned about his property. He was
it was concerned about something else. It seems like his embarrassment and his rage over being caught abusing a dog by stabbing it in the throat with a broomstick. And of course, the government only has to show that the trial court, a reasonable person, could reasonably conclude that one of these elements, the government disproved one of these elements beyond a reasonable doubt. And so no matter what element you take, there was evidence for which a reasonable person could find that the government had disproved the element by a reasonable doubt.
Mr. Sable, I'm sorry to interrupt you briefly, just to let everyone know that Judge Farron has joined us by audio. And he was having some difficulty connecting earlier, so he is with the panel now. So I'm sorry, Mr. Sable.
Good morning.
Good morning,
Judge. With respect to Judge Thompson's question, it was my reading of the record that the court found that the attempt threat was the driveway, the second driveway incident that Mr. Whitehead described. That is to say, there's an incident in the laundry room where she comes in and he says, "I'll have your mother put you out right now. I'll get your mother. Your mother doesn't want you here anyway." And then there's the incident that he leaves and comes back 90 seconds later and makes a threat from 21 feet away. And then from 5 feet away, he says, "Make your motherfucking daughter leave. If you don't make your motherfucking daughter leave, I'm going to make her leave. I'm going to wipe her little ass out. I'm going to wipe her black ass out." And while
this is
waving
when he's
this
in
blade,
the yard still, he hasn't entered the house. Is that
Yeah,
what's happening
so-
at the time?
right?
Because there's testimony that he went into the house and then later he reappears while Kayla is having this argument with Vanessa. And when he reappears,
right. That's
so you're thinking that's not it. It's before he enters the house.
It's yes. Before he goes back into the house, before she gets the spoon, he threatens her and he's standing 5 feet away from her, waving this 5-inch long blade and threatening to wipe her ass out. And that's what the court, as I understood it, found to be the offense conduct for which he's convicted. And that was, and again, if you look at the first element, I think Judge Blackburn Rigsby focused on this, that, he may have authority to bar her from the property because he's a lawful occupant of the house, but he doesn't purport to have that authority. He doesn't say to her, "I'm telling you to leave." What he says is, "I'm going to get your mother to tell you to leave." That does not revoke her permission to be there. That, taking those words at face value, he does not make her a trespasser by saying, "I'm going to get your mother to leave." And so that's on that ground alone, the government proved its case. And a reasonable person could find that she was not a trespasser. And I would note that the defendant's theory at trial was, "I didn't threaten her, I didn't have a knife." And then at MJOA, he came up with the defensive property theory, where his theory was that her permission to be there was revoked by appellant. So the question was always at trial, did appellant revoke her authority to be there? And the words that he spoke as came from the only witness who was credited do not establish that he rendered her a trespasser by excluding her.
Well, Mr. Sable, the government cites in their brief and relies on the Saidi case.
Yes.
And that, I think there are some things that distinguish this case a bit in a way that may not be as helpful to the government. I mean, this isn't an instance, despite the words that Mr. Johnson was using, where it seemed pretty clear he didn't want her on the property. And the threats that he made, the knife or the blade box cutter that he brandished seemed to make clear that he didn't want her there. How does that square with your argument and even the question that I asked of appellant's counsel earlier?
Well, I think she's entitled to take his words at face value. She may know that he doesn't want her there, but he's not saying you're not allowed to be here. He doesn't seem to think that he has the authority to say that. And certainly, I don't think there's any way appellant can show that a reasonable person viewing these facts couldn't conclude that she wasn't trespassing, because it seemed that she was being told, you're going to be excluded, but you aren't now.
We had inferred, and I know I inferred from reading the record and in some of the questions that I posed to appellant's counsel, that, you know, she was regularly on the property, in and out, because her
Yes.
mom was there, or niece. Is there something in the record or in the trial judge's findings that you could point us to that would support that inference more strongly? And
there were sort of two clusters of facts, Your Honor. One was the grandmother is babysitting the grandson, and she's picked up either by the daughter or by the other daughter. And when the victim gets there, she calls the mom to say, send the nephew down because I don't want to see your husband or appellant. And so there seems to be a regular scheme. A person could infer a regular scheme to pick up the grandson from the grandma's house where he's babysitting. And then there's also her mention that she had permission to be there. She said, I was there earlier. We don't know exactly how much earlier. She said she didn't need permission. It's her mother's house. She believes she had permission. I think a reasonable person can conclude she was credited by the court. A reasonable person can conclude that she had a basis for believing there was some sort of implicit understanding from the grandmother, from Vanessa, that she had a right to be there. I think the question at trial, as I said, was, did he revoke that? And I would say that he did not. But if I can, Your Honor, I would also like to point to Saidi and also to Gatlin, because they're very pertinent to the second element, which was, even assuming that she was a trespasser, what was he defending? And in both of those cases, the court found that there was a basis to find that the defendant was not acting to defend his property, but out of some other motivation. So in Gatlin, when the principal snatched the notebook out of the reporter's hand and said, leave, the court could find reasonably that she just wanted the notebook back because the reporter had taken some embarrassing notes that the charter school principal didn't want her to have. And then in Saidi, the defendant told the guy, the Good Samaritan neighbor, to leave, and then he punched him in the chest. And again, this court said, well, there were facts from which a reasonable person could conclude that he didn't punch him in the chest because he wanted him to leave. He punched him in the chest for some other reason, because he was angry at his intervening in his argument with his roommate. And that's the same thing here. I mean, it may be that a different finder of fact would look at these facts and think that he was trying to exclude her from the property. But this court found no evidence that he was trying to exclude her from the property, that he was trying to defend the property as opposed to some other motivation. And we have abundant evidence of that other motivation. He was drunk, he was high, he was angry, he was torturing a dog, he was caught doing so. Presumably he's very embarrassed and he's high and he's enraged. Turning to the third element, if I can, we know, of course, as counsel's pointed out, that the threat to use force is not necessarily to be equated to the use of force. And so we're not necessarily to assume that his threatening deadly force is the same as using deadly force. But we do know that the use of force or the threat has to be reasonable under the circumstances. I think the thing that separates this case from Jones and even from Yancey is the fact that after the initial encounter in laundry room driveway, and she's only there for a minute and a half, according to her testimony, before he comes back and threatens her with a box cutter. So any intrusion on his property is minimal. It's absolutely minimal and cannot be justified by what he did. Certainly, the finder of fact makes a factual determination about whether that use of force is reasonable. And this court had abundant facts to find that it was unreasonable under these circumstances. And we did cite to the court yesterday, I hope you all saw them, we had some technical difficulties with the filing, the 2 California cases that essentially said that. One case in which the somebody escorted someone off the property by threatening them with an axe, and the other case in which some
Right, Mr. Sable, your screen is frozen a bit on us, and we're having trouble hearing you.
pointed a gun 5 feet to a repo man, and that was defense. Talking to myself there for a while. Can you see me now, Your Honor?
We can see you. I heard a bit of the last sentence about a case involving a repossession repo man. And I
Right.
didn't hear what you said right before that because your screen froze
Sure.
a bit.
I was talking about the excessive force element and noting, distinguishing Jones, and then I talked about Yancey and talking about the 2 California cases. One where someone used an axe to escort somebody off the property and defensive property was not available because the threat itself was excessive. And the other in which someone pointed a gun at a repo man's head and said, get off the property. And that was a threat of force that was also excessive, rendering the defense of property defense unavailable. So for any of those reasons, Your Honor, the court could reasonably have found that the government disproves the defense.
Mr. Sable, can you hear me?
I can, Judge.
Sorry to have been parachuting in so late here. I just wanted to clarify one thing in my own mind. I take it your principal argument is that she was not a trespasser and there was an assault, basically an attempted threat. That's the end of the case. I mean, that's where your principal argument takes you. Is that right?
I don't think so, Your Honor. I think all of the elements, there was evidence from which a reasonable finder of fact could find the government proved its case on all the elements. And the court made a statement after finding that the government had disproved the defense that there was no evidence that the defendant was acting in defense of property. I think that's understood as a very specific motive, that there was no evidence.
Well, excuse me, I'm not sure you need to get to that. If she was not a trespasser, what more do you need to show?
Nothing.
Other than that. All right, well, that was what I was trying to clarify. And
Yeah.
And there was an attempted threat by virtue of the fact that his actions very close to her with that box cutter.
Yes,
Okay.
exactly, Your Honor.
Thank you.
And just to nail down another fact, do you agree with Mr. Whitehead that Kayla was parked in the driveway as opposed to the alley? There are a couple of places in the transcript where she says she was parked in the alley, though she does say at one point she was parked in the driveway. Do you agree with Mr. Whitehead that it was the alley? I don't know whether it makes a difference or not, but conceivably it does.
That was the way I took the record, but I would need to look at that again before saying definitively. But I do remember the discussion about the alley. I had thought that she was still in the driveway, but she had retreated, and so she might still have been on the property, but the intrusion would have been de minimis at that point. Certainly nothing. And I would note, Your Honor, there's no reason, given that de minimis intrusion, that he couldn't have called the police and waited for the police. This was, in Jones, for example, that's a homeless woman sleeping on her box in the metro in her usual spot, and the guy's got his feet in her face on her box. There's no police around. And in Yancey, the guy's going to steal his saddle if he doesn't do something. So they don't have an option to resort to the police. But, we don't want people taking the law into their hands in this extreme way if there is a real option for police presence. This isn't the Wild West.
All right. Thank you, Mr. Sable.
Thank you, Your Honor.
Mr. Whitehead, you have I think you reserved about 3 minutes for rebuttal.
Yes, thank you, Judge. Just to respond quickly to that last point, the Gatlin and Jones says that the police have to be called only if they're on the scene. The police weren't on the scene, so that's not a bar or obstruction for Mr. Johnson to act in defensive property. In terms of Judge Farron, your question about trespass and whether or not she's a trespasser, the record absolutely shows that she is a trespasser. She does not have lawful authority over the home. She does not live there. Whether or not she's invited sometimes or she has permission on occasion, at the time, Mr. Johnson told her she needs to leave the house. And the government doesn't dispute that she should have known that he did not want her there. And that he was saying that even your mother doesn't want you there. And
well, didn't he every time say your mother didn't want you there? I mean, I'm not sure that at least I saw where he himself, as a lawful occupant and a lawful person to exclude trespassers, simply said, "I want you gone." Didn't he always incorporate a reference to her mother?
He did, but I think even when the government says that she understood that he did not want her there, if you look at a reasonable interpretation of your mother doesn't want you here anyway, I'm having your mother put you out, F all you all. If after somebody had just burst into your home and started cursing you out and kirking out on you, could not be considered, hey, why don't you wait here and I'll have somebody else put you out. This is the equivalent of, I'll have the cops put you out. You're not welcome here at all, to the point where I'm willing to go get somebody else to help get you off of my property. So even though there's no magic words where he has to specifically say, get out, it's a mere demand. And based on his language and anger and the way that she treated him upon just bursting into the house, it was readily understood and is the only reasonable interpretation that he was trying to eject her at that moment. And from that point on, she was on notice that she needed to leave. In fact, she did walk out of the house, even though she did not leave the property and didn't leave the premises. She got into her car, she had the dog, she had the nephew, she had everything that she needed, yet she claimed that she had to stay there because her sister told her to stay. Well, it isn't her sister's authority to tell her to stay on somebody else's property for which she's been demanded to leave. At that point, it is incumbent upon her to get out, or else Mr. Johnson has the right, as in Jones, the right to use reasonable force. The government's main thrust of their argument is focused on this motivation. Now, this court has to find, even when there's potentially mixed motivators, beyond a reasonable doubt that defensive property has to be excluded as a motivation. And that simply cannot happen in this case, where every single specific testimony that Kayla gives about what Mr. Johnson says is paired with his desire to have her ejected from the home. From the beginning of the conversations, which is, I'll have your mother put you out, she don't want you here anyway, to on the way back to the home, which is, get your daughter to leave. If you don't, I'll make her leave, to the threat itself, which is paired with, get your MF daughter out of here, make her leave. If you don't, I'll make her leave. I will wipe her out. And so there's no way that this court or any reasonable fact finder could parse out some general anger that he has or dislike that he has from Kayla and his desire to have her ejected from the premises. And lastly, and quickly, that his actions were completely reasonable. The government doesn't cite any cases for where the mere threat of force is excessive.
Well, but again, when you say his actions were completely reasonable, he's brandishing a bladed weapon at essentially his daughter-in-law, if you will, who's been to the house many times, who was there to pick up her nephew. That does seem to be at least really getting close to that line of unreasonable. She had not pulled a weapon on him at that point. She had not threatened him in any way at that point. So I do find that to be a troubling aspect of this case.
Well, there are 2 points to that. The first, the
Seems to be
familiar
an
relation.
unprovoked threat of violence by him. And I think that that is my biggest issue with this case.
Well, it isn't absolutely provoked because she is committed what's the equivalent of an unwanted entry. She is a trespasser because she is not wanted on the property. She's refused demands to leave, just like Jones, where Miss Jones asked.
Oh, but at the time he brandishes the knife, she has left the house, walked down the driveway, and gotten into her car.
Well, but
right?
she's still on the property, and she could have left by then. I mean, she says that she's in the car, she has her nephew, she has the dog. She could have, and the government admits in closing argument that a prudent person would have left. She should have left. In fact, she gets out of the car to confront Mr. Johnson, who is approaching supposedly with this box cutter. But she's still on the property, and the government does not dispute that the driveway was part of the property. When you ask somebody to leave your home, you don't say, well, get out of my house, the 4 walls of my house, but you may stay on my porch. That's not the case here. It's leave the house, leave the premises, leave the property. And in the same way that Jones, the complaining witness, had his feet on her cardboard box on her home, this is the same instance where Miss Kayla Harris has her feet on Mr. Johnson's home. And at the point where she's a trespasser that refuses to leave, it doesn't matter what their familiar relationship is. She's volatile. They don't like each other. She is kirked out on him, and he has the right to use reasonable force. And what force could be, it can't be any more reasonable than to just use a threat, whether or not he has a box cutter in his hand.
I understand your argument, but that's where I have the biggest difficulty with the argument, Mr. Whitehead, that he's brandishing a bladed weapon at her at the point in time when she had retreated back to her car.
But she's actually still on the property, which I think is the main point. In that, this court has said, as I quoted in Jones earlier, that merely threatening while displaying a deadly implement is not the same as using the deadly implement. So he's not charged with assault. The court never found that that gesture was assaultive in any way by approaching with the knife.
Charged with the threat. The threat.
He was, yes. I'm sorry. When I meant not charged with assault, he was not charged with simple assault. He was not charged with possession of a prohibited weapon, which requires the intent to use an implement as a weapon, which he could have been, but he wasn't. The government did not do that. The court didn't make any finding that he was using the box cutter as a weapon or using it in terms of an assault with a dangerous weapon. This was strictly focused on the threat, and a mere threat, and that is the threshold, the minimal amount of force that he could have used, and we know that it didn't work. So with all that being said, I know I went well over time, but I would again look to Jones and look to Yancey, and the government's cases don't apply because in one of the cases, I'm sorry, forgive me, but one of the cases, there was a gun pointed at somebody's face and saying, I will kill you, never even asking that person to leave the property, the repo man to leave the property. And when the repo man said that I'm here to collect the car, I'm here on orders, he said, I don't care, I'm gonna kill you anyway. So that's certainly unreasonable. And the other case was about forcefully ejecting somebody from your premises. The court said using force. So actually taking the person, but it had a knife, axe in their hand. So that is completely different and was convicted of assault. So for all the reasons that we've stated, we ask that this court reverse. Thank you.
All right, thank you. And I'd like to thank both counsel for your arguments and for your patience as we have navigated some technological issues this morning. Thank you.
All right, have a good day.
Bringing in the next case.
All right. All right, good morning, Council. Thank you for your patience. We're a little delayed this morning due to some technical issues. This is the second case on our calendar this morning for oral arguments. It's the matter of RFB Properties LLC versus Federal National Mortgage Association. Council, are you ready to proceed?
Yes, Your Honor.
All right, Mr. Brand.
Thank you. Good morning, Your Honor. If it pleases the court, I'm Michael Brand. I represent RFB Properties in this matter. Let me apologize in advance for what may be the sound of a jackhammer behind me. They're doing apparently some concrete work on the building in which I'm located, and I've been listening to them throughout the early part of the court session.
It's understandable, Mr. Brand. We've had a number of interesting glitches this morning, so why not a jackhammer?
Yeah, why not that too? Why not?
Thank you.
As you all can see, I just wanted to make sure you're aware that we're joined by Judge Thompson and Senior Judge John Farren, who's joining us by audio only.
Yes.
Good
Thank
morning.
you, Good morning, Your Honor. Your Honor, the primary, I'd like to reserve 3 minutes for rebuttal, if I may. The primary question to be considered on this appeal is the effect of the administrative revocation and subsequent reinstatement of the plaintiff under current DC law. Defendant would have the court adopt the rationale of two outdated cases decided under the prior law, the Accurate and Bordeaux cases. Although Bordeaux is, of course, a U.S. District Court case, without consideration of the effect of the Business Organization Enactment Act of 2010. That statute is based on Section 1-603 of the Uniform Law Commission and the ABA Model Act. And when the new DC statute is read in conjunction with these model acts, the effect of the amendments become clear. Both
Mr. Brand, can I ask you, you're referring to 29-106-03,
C.
the C or D?
C.
The reinstatement provision, which is D, I believe. It reads that when reinstatement under this section is effective, it shall relate back
Yes.
to and be effective as of the effective
You're
of
right.
the administrative dissolution.
That's
Now, was
correct.
there was a similar provision in the earlier statute, wasn't it?
Well, it was different. It was different, and it was different in a couple of ways. It was different because it didn't use the term relate back, and in fact, the concept of relation back was something that was addressed in the Accurate case, because in the earlier decision, the earlier language just stated that upon reinstatement, the dissolution shall be annulled, and such corporation shall have the same rights as it had at the time of the issuance of the proclamation dissolution, with the same force and effect as if the proclamation had not been issued. There are two very distinct changes in the statute that explain how the reinstatement is now to be treated. First, the old statute was forward-looking only, and that is while it used such terms as annulled, which does not seem to imply retroactive application, stating that the corporation shall have the same powers it had at the time of the issuance of dissolution, it did not specifically state that the reinstatement related back, as the new statute does.
So can I clarify? I know that was your argument that the annulment language in the earlier version of the statute was sort of prospective looking. So your argument, as I understand it, is that this provision means that once RFB paid its fees to reinstate its corporate authority, that related back to the date and time when RFB was suspended administratively, which was what date?
I do have it. It was revoked on September 10th, 2017.
Right, and that that date in your argument precedes the November 2017 actions by Fannie Mae to take title
Yes.
to the property, and therefore
Yes,
anything that happened between September and November during that period you were administratively suspended was cured by paying the fees to reinstate your corporate status, right? So that's one argument I hear you making.
yes.
I also hear you say making another argument that the cause of action actually arose before November of 2017 when Fannie Mae sought to take possession of the property. And it also preceded, the cause of action also arose before September of 2017 when you were administratively revoked. And in some of your earlier arguments, you talk about the cause of action arising back in December of 2016 when Fannie Mae first filed its complaint. So I guess I'm confused about whether you're saying the point in time that the cause of action arose doesn't matter because of 10603D, or whether even if it does, the cause of action arose before November of 2017.
That's exactly right. I mean, we think that the date the cause of action arose really doesn't matter because, in fact, once the reinstatement occurred, it related back and cured. And that's the distinction in the that's made with the accurate decision, because the great weight of authorities that's recognized by accurate was that it's generally held that a repeal charter relates back to the date of the proclamation of the repealer and validates corporate action taken in the interim unless under the statute the delinquent corporation is during the period of suspension wholly without the power to act or contract, and its attempted acts or contracts are entirely void. And at that time, the court said, we think this exception characterizes our statute. And that's what the defendants are relying on. And that's actually what the court.
So is your argument that during that period you were administratively, your corporate status was administratively revoked, you could do anything as long as you then later turned around and paid the fees to be reinstated?
I think under the current statute, anything that was done during the period of revocation was in fact validated once the revocation was reversed, and that shows from the statute itself, from the second change in the statute, which said because the statute says that.
Now, how do you read that? If I could just read this language in section D, it says when reinstatement under this section is effective, it shall relate back to and be effective as of the effective date of the administrative dissolution.
Right.
And the domestic filing entity shall resume carrying on its activities and affairs as if the administrative dissolution never occurred, except for the rights of a person arising out of an act or omission in reliance on the dissolution. Isn't that, didn't Fannie Mae in its corporate status rely on steps it took to retain and or reacquire title to the property that would prevent the relation back clause from applying in this instance?
No, Fannie Mae doesn't claim that it took any steps in reliance on the dissolution, and the trial court actually attempted to submit to find that to apply that language, but it doesn't really work. Because what the trial court said is that the defendant is, excuse me one moment. The trial court said that Fannie Mae may claim that the plaintiff's failure to legally record its deed to the property during the period of dissolution vested legal rights in the defendant. That's purely speculative. Defendant never made such a claim, and it couldn't form the basis for a motion to dismiss in any event, because there's no factual finding of that. But also because such a claim would not be a claim based on reliance on the dissolution. It would have been reliance on the fact. It would have been reliance on the fact that there was no deed recorded, but that has nothing to do with the dissolution itself. And Fannie Mae never claimed that the revocation had anything to do with the dissolution, let alone that the defendant relied on it.
Let me ask one other question, and then I will. I know my colleagues have questions as well, but I'm curious as to why you didn't really cite the TK case. Neither party seemed to rely on that case, and TK versus National Community Investment Coalition is a 2013 case from our jurisdiction, and it's actually referenced in the end notes. Discussing the statute, the new statutory provision under 29-106-03.
We did cite it actually. Because in that case, the Court of Appeals reversed dismissal of a counterclaim based on contract claims that arose prior to the period of revocation. We cited it on page 22 of our brief. So we felt that
is that case distinguishable because there was no dispute that the revocation occurred prior to the claim at issue?
I'm not sure I follow what the court's saying.
Is that case applicable here? Because it seems like it would resolve many of these issues that we're discussing here.
What did you say about it in your brief?
We said we didn't cite it as a major consideration, but we cited it on page 222, where we were talking about inquiry notice, where inquiry notice in such circumstances include inquiry notice as to the state of the record, as well as the actual possession of the property, because we had indicated that Fannie Mae had known that our client was in possession, citing also to TK versus National Community Reinvestment Coalition, where this court reversed dismissal of a counterclaim based on a contract claim that arose prior to the period of revocation. So that was, so our claim was because the claim arose prior to the period of revocation. The plaintiff could maintain its action.
So then your argument would be that our TK would apply here if we take the December 2016 date as the date that the claim arose here, which would be prior to the date of revocation. Okay.
I'm kind of intrigued by your argument, Mr. Brand. Oh, I'm sorry. Were you giving a further answer to the Chief's question?
No, that's fine. Thank you.
I was going to say, I'm kind of intrigued by your argument that the cause of action accrued when RFB purchased the property at the condo association foreclosure sale. I know you said a few moments ago that when the cause of action arose doesn't really matter because of the new statute. But putting that point aside for a second, you seem to argue that because under our case law relating to super priority liens, Fannie Mae's lien was extinguished upon the sale to RFB, that kind of answers the issue here. What is that an argument that you've made only on appeal, or what's the status of that argument?
No, I think we've made it previously. The fact is that I think this was an evolving area of the law at the time of the foreclosure sale purchase. At that time, the Fannie Mae deed of trust was still on the property, so it amounted potentially as a cloud. The actual effect of it at the time was unclear, although the Chase Plaza case had held that it's extinguished. There were certain other questions still existed, and so there's a question, and I don't think it's that question has been completely formulated in the defendant's motion. Our position would be then that at that point they could have filed a quiet action, but perhaps were not compelled to, depending on the evolving state of the law, which doesn't mean that the cause of action didn't exist, which is because there were issues that were still yet to be decided.
In any event, that purchase was before the period of suspension. Is that correct?
Absolutely.
Do you, by the way, understand the rule about the rule that relies on when the cause of action accrued? I know that it comes out of our case law. I understand that, but why is that a relevant date? Why was it a relevant date, at least under the old statute? What is it about the date of accrual that should dictate whether an action can proceed when there's been a suspension?
The trial court found that if the cause of action accrued during the period of revocation, that if the injury occurred during the period of revocation, then the plaintiff could not rely on the injury, could not sue on the injury.
Right,
So,
and I think the court relied on accurate, and that's probably an accurate application of that case. But what I'm asking you more is the rationale. Do you understand the rationale of that rule?
The rationale of that rule is based on the statute.
The old statute, the old
Yes.
version of the
Yes.
statute?
Yes, the old version of the statute, which we believe has been abrogated by the newer version.
In that,
Well, certainly the old statute would have said you don't get to sue. I'm not remembering its language, but I'm just wondering whether it actually dictated the result that you look to the accrual date. Well, I don't know. I'd have to be looking at the language. Thank you for that answer in any event.
All right. So is your argument, Mr. Brand, that the accurate decision, which said that the revoked corporation can't sue during, if the cause of action and injury occurred during the time that their status was revoked, that you're saying was the law based on the earlier statute using the annulment language?
Yes.
That didn't relate back?
Yes.
Okay.
All right. I think I've used up my time including
Okay.
my rebuttal.
Well, we'll reserve a couple minutes for your rebuttal as well. And Judge Farron, did you have a question for Mr. Brand before we move to
No,
hear
we
from the
can go
appellee?
on, thanks.
All right, thank you.
Thank you.
All right, counsel. Is it Duig? Mr. Duig, am I pronouncing it correctly?
Yes, Your Honor. Good morning.
Mhm.
Peter Duhigg for the Appellee Federal National Mortgage Association, Fannie Mae. May it please the court, it's Fannie Mae's position that the trial court was correct when it concluded that RFP's quiet title claim accrued when Fannie Mae purchased the property back in November 2017. And that's when a cloud was created on RFP's title. And because of that, and because RFB was administratively dissolved at that time, it didn't have standing to maintain a quiet title action because administrative dissolution is a punishment under DC law, which isn't
So,
erased by reinstatement.
Can you help me with this argument, Mr. Duig? How does that argument square with 10603D and the relation back language there? Because it seems like the analysis that you've set forth applies under the old statute, under the old statutory language perhaps, and under the accurate decision, which seemed to be interpreting that older language.
The revisions to the statute, Your Honor, we do not believe changed the result. In the court's ruling inaccurate and the district court's ruling in Barbeau, and in the ruling out of the Eastern District of Virginia. And looking at the statement or looking at the code section D, it does say when reinstatement under the section is effective, it shall relate back to and be effective as of the effective date of dissolution. And that the entity shall resume carrying on its activities as if the dissolution had not occurred. So the language there, shall resume, states that the dissolved entity wasn't in a position to act as it normally would had it administratively dissolved. And as far as the reliance language in that statute, Your Honor, I just don't think it matters. I mean, Fannie Mae isn't saying RFB, you can't continue as a reinstated entity. We're not contesting that. What we're saying is that under DC law, because the quiet title action accrued while you're administratively dissolved, you can't use that. You don't have standing to use that to bring this cause of action because you're relying on the benefits of the actions you took while you're administratively dissolved, meaning recording the deed, which it waited 3 years to do, and filing the action. Otherwise, the statutes would have no teeth because the
Let me ask a question, sort of a hypothetical that I think comes from one of the cases, the federal decisions. I mean, suppose during a period of time that a corporate entity is status is administratively revoked because they didn't pay their corporate dues or taxes or fees. Suppose during that time they suffer some other kind of financial loss, burglary or something that wipes out their financial assets. Are you saying that during that time they couldn't take any actions to recoup their resources or reserves or file suit or get protection under the law to recover items that may have been stolen? I mean, that's perhaps a far-fetched hypothetical, but you're saying they couldn't do anything that might help put them in a position to be able to reinstate and restore their revoked status.
Well, just to distinguish, a corporation could take an action to reinstate, but if you're administratively dissolved, it's not that the administratively dissolved entity can't do anything. It
What
just-
can they do? That's what, in your view.
So it can act for the purposes of winding up and nothing more. And that idea has been constant throughout the revisions of the code. And that's what Accurate says. It says that an LLC, once it's been administratively dissolved, is shorn of all its powers except for winding up. And there's no allegation here that RFB was winding up. And in fact, it's just the opposite. It continues to, stated it's renting out the property. It's continuing to act. So that's the distinction, Your Honor.
Does the record support that Fannie Mae acted in reliance on the dissolution before knowing or having a reason to know of the reinstatement?
Your Honor, yes. I mean, we relied on that when in defending this action. But again, I don't think the reliance language, I just don't think it matters here because
Does action in defending against the suit count as one of the acts or omissions that the statute refers to?
Well, I think it can, Your Honor. But again, I just don't think it matters. It would matter if we were saying RFB properties, I don't care whether you're reinstated or not. I relied on it and you can't do this. That's not what we're saying. What we're saying is that RFB can't maintain an action for an injury that is sustained during a period of administrative dissolution. And that's how those two code sections square up with each other. I mean, dissolution is meant to be punishment. Otherwise, entities could neglect to file their biannual reports or pay their taxes. And then as soon as it's discovered that, oh, I forgot to do that, they can just pay the fees and get reinstated without any consequence. The dissolution has to happen.
Well, Mr. Duig, I see the language in section D of the statute that you're referring to that says that the filing entity shall resume carrying on its activities. And if your interpretation is the correct one, then why do you also need to say it shall relate back? Why does the reinstatement need to relate back if it only allows the corporation to pick up and resume operations from the point in time that it reinstates itself?
Well, because otherwise I think it would have to go through whatever process there is to begin the corporate entity again. But it just, the statute doesn't say that an LLC can sue for injuries that were incurred during a period of administrative dissolution.
Mr. Duig, I've got one question, and that is, does this exception clause, was that put in there primarily, if not exclusively, to permit third parties that have claims against a corporation that is technically dissolved for whatever reason, to preserve their right to file claims against the assets or contract rights, whatever you have, in contrast with any plaintiff's rights that the corporation that's under dissolution would no longer be able to assert during that period? Is there a distinction between those two statuses that is reflected in that exception?
Your Honor, there may be, but again, I don't think it stands for the proposition that an entity can sue for an injury that accrued while it was administratively dissolved. Otherwise, the dissolution statute would have no teeth. And there's nothing in the statute or any case law that shows the opposite. Accurate in Borbo, there's still good law.
You emphasize the point that dissolution is meant to be punishment, and I recall seeing that idea in case law from the past. And I can't recall whether in your brief you told us whether anything in the legislative history of the current statute picks up that idea, does it? I mean,
Your Honor,
when the relate back language and all of the language of 29-106.03D was adopted, was it said that dissolution in these days is meant to be punishment such that it requires the result you urge?
no, Your Honor, we did not cite any legislative history. We don't think the statute is ambiguous. And the notion that dissolution is punishment has been consistent throughout the cases.
Yeah.
The idea of dissolution being punishment goes back to at least accurate in 1977.
Well, what's the significance in your view of this new language in the statute, 29-106.03D? What change did it actually make, and what was the significance of that change? Mr. Brand talked about the use of the word annulment in the prior iteration versus the relate back language in this iteration. What was the significance of this new language in the statute?
Your Honor, we don't think that it really makes any difference in this situation because the injury accrued while RFB was administratively dissolved, and there's nothing in this language that states otherwise. I mean, whether you use the word cancel or annul, the effect is the same here.
But what can you give us an example of where this new exception would apply? I mean, they put it in there for some reason.
Well, Your Honor,
and of course, the Kentucky court has used it in a direction that Mr. Brand is happy with, and it just seems to me that it would be useful to have a sense from you as to exactly what the parameters of that exception are intended to surround.
Okay, and I think Your Honor is referring to the Pinnell case out of Kentucky, and I believe the Kentucky statute is likely similar to the one here, but I think the case that case is distinguishable, where the plaintiff in that case was seeking to impose personal liability on a member of an LLC for a lease. There's a question of whether she signed personally or as a member of the corporation, but otherwise the limited member would have been personally liable because the LLC had lapsed. So I think that case is different from the facts here.
I asked.
Well, let's just assume that's true, and I think you're right. But I still don't understand where this new exception that huge committee obviously thought was essential is intended to take us. Now, it may not apply in this case. I'm not arguing that. I'm just trying to get a better feeling for why it's there, what it's supposed to accomplish, and thus why it doesn't affect you.
Well, Your Honor, I think it's there to Your Honor, I'm just not sure it matters in this case because it doesn't change the fact that RFB cannot sue for an injury that it sustained while it was administratively dissolved. And the change here doesn't address that situation. It's what we have here.
Mr. Duick, I asked Mr. Brand about the TK case, TK versus National Community Reinvestment Coalition. Is that case applicable here, and why not?
Your Honor, I don't believe that case is. I think that case involved the it involved a lease, and the question was whether revocation had an impact on the lease. And so the corporate, I think the entity in that case was reinstated, and I believe the court held that that the administrative dissolution did not cancel the lease, and I think that's why that case is distinguishable than here. It's not really talking about an injury. I don't think that was accrued during a period of dissolution. It was talking about the cancellation of the effects of administrative dissolution on a lease that existed beforehand. Your Honor, I do see that my time is up. I did want to note something about when the claim accrued, and I think the court was correct about that. And it accrued in November 2017 because that's when RFB discovered a controversy. And
What's wrong with the theory that it accrued when, at least arguably, Fannie Mae's interest in the property got extinguished upon the foreclosure sale by the condominium association? What's wrong with that theory?
Your Honor, I think there are a number of things wrong with that theory. One is we don't believe that Fannie Mae's deed of trust was extinguished at that sale back in 2014, which I believe was just a few weeks after this court's decision in Chase Plaza. And Chase Plaza dealt with the foreclosure of a 6-month priority lien, and just a 6-month priority. And in this case, the foreclosure was for much more than that. If you look at the notice of foreclosure of condominium sale that is in the appendix at page 10, the foreclosure is for $46,857. That's much more than a 6-month super priority. So we don't think that Chase Plaza helps RFB here. And to say, oh well, there may be a cloud. I think it's just too tenuous. When in our response to our motion to dismiss, RFB's managing member filed an affidavit, and it stated that it discovered by searching the internet that a property was being foreclosed on by Fannie Mae. It immediately paid a lawyer, sent a notice to the foreclosure council, and this was recorded the deed. This is all within a few days of November 17th.
Well, in answering my question, you seem to emphasize that the condo association foreclosed on more than 6 months condo fees. And as I'm sure you know, there's some post-Chase Plaza case law dealing with what happens when the association forecloses for more than 6 months. But beyond that, your answer to my question did not seem to be, oh no, a cause of action, a quiet title action couldn't accrue then. Your answer was more it didn't, because the association was seeking to recover more than 6 months. Are you agreeing implicitly that the cause of action for quiet title could accrue upon extinguishment of a lien in a super priority lien context?
Your Honor, I
mean, do you understand my question?
Maybe you should repeat it, please.
Well, I'm just saying, when I asked you about what was wrong with the theory that the cause of action arose when, at least arguably, Fannie Mae's interest was extinguished, your answer was not that circumstance could never be a cause of action for quiet title. Your answer was no, it didn't. What's wrong with the theory is that the association foreclosed to recover more than 6 months worth of debt. And so my question is, are you kind of implicitly agreeing that had it foreclosed for only 6 months worth of debt, or if it was considered to be only seeking 6 months pursuant to 4700 Connecticut and Liu and all the other cases that followed Chase Plaza? Are you agreeing that could have been the moment when a cause of action accrued?
No, Your Honor, we're not agreeing with that because, again, RFB just didn't know about the claim. There was no controversy at that point. RFB informed us that it found out about the claim in November 2017 while it was administratively dissolved.
Well, that's what caused them to proceed. But if the issue is more sort of the theoretical, when did a cause of action accrue? I just wonder if it could be somewhat earlier. I don't know. I mean, you might want to say, well, go look at the complaint and see what they were complaining about and what they thought was the accrual of their cause of action. And perhaps that's the right answer. I'm just not sure.
Your Honor, I think there has to be something more than that for a cause of action to accrue. There has to be some controversy. You have to know about it. And that didn't happen until November 2017. As stated in Mr. Brown's affidavit.
What about the argument of a potential cause accruing at the time Fannie Mae filed its complaint for the judicial foreclosure sale? That would have been in December of 2016. Why couldn't that be viewed as a point in time when the cause accrued?
Yeah, I think it's the same because there was no controversy with RFB at that point. And RFB hadn't, again, it didn't discover its claim until November 2017. It had not recorded its deed until November 2017 when it was administratively dissolved. And so it would have to be enforcing its rights under a deed that was unrecorded, and that can't happen against third parties unless you record it.
All right. Any other questions for Mr. Duick? Thank you, Mr. Duick.
Thank you.
Mr. Brand, we've reserved a couple minutes of rebuttal for you. Okay, Mr. Brand, you have to unmute, please. You're still muted? Okay, now, thank you.
All right, just very briefly, I'm sorry, I didn't see it. The argument that counsel seems to be making is that the relation back language has no effect at all. If the reinstatement is prospective only, then relation back doesn't mean anything.
Well, what I understood Mr. Duick to mean, it does give the advantage, in his view, of saying that the corporate entity doesn't have to newly incorporate itself again. That at the date in time or point in time that it takes steps to reinstate its corporate status, it can just continue on operating as a corporation.
There's no real,
that's his argument. Huh?
I understand. There's no support for that, and the traditional interpretation of that within the states before the adoption of this language here didn't support that. It was that it related back, and actions taken in the interim were confirmed. He's also indicating that it's intended as a punishment, and if the court adopts the relation back argument that we're suggesting, that punishment is abrogated. I don't think that's right. I think that there is still a punishment. It's a punishment that during the period of revocation that you're limited, that there's very few things that you can do, and you can only and these things are only accepted or only operable once you reinstate. So there is certainly.
Can you
there's
explain what you, I guess, maybe give us an example? Mr. Dewig mentioned that clearly a corporate entity that's suspended administratively can take steps in any steps or actions relating to winding up the corporation. And you're not arguing that being able to bring suit to quiet title is a step towards winding up the corporation, are you?
Well, actually, there was an argument made in the Kentucky case that bringing an action such as this could indeed be be construed as a winding up because you were marshaling assets, and that could be deemed as winding up. It's not furthering. It's not necessarily furthering its ongoing activity. It could just be a marshaling. No, what I'm saying is that there is still a punishment.
But what other actions is a revoked corporation able to take other than winding up? So in other words, if we didn't view the bringing a suit to quiet title as falling within the category of a winding up activity, what other authorized activity that corporations, in your view, can take during their revoked status would the efforts to quiet title fall within?
I think it's likely that the court would find that during the revoked status, the entity wouldn't have access to the courts, and generally, so there is still a punishment. There is still a punishment issue there.
Well, if the revoked entity couldn't have access to the courts during the period of time it's administratively revoked, how would that permit RFB to file a lawsuit to quiet title during the period in time that it was revoked?
Well, this action got reinstated. The RFB's powers to maintain the cause of action sprung back into existence once it's filed for reinstatement.
So your argument is that actions that a revoked corporation normally could not take, i.e. file a lawsuit while they were revoked, are sort of blessed retroactively once they reinstate their corporate status?
I think that's what relate back means. Yes. And
based on what? Like, what would be your best authority for that? So a corporation could do anything that they are not authorized to do while they're revoked. And once they reinstate, those actions that they took during their revoked status would be, what's the word I'm looking for? Washed, laundered.
Well, we don't want to.
Ratified.
Ratified.
I'm sorry.
Thank you, Your Honor. I think that works. No, I think that's.
Mr. Dewig might prefer the other description.
He may, but I think that's the historic. That's the generally accepted concept, and I think that's a concept that even existed generally throughout the country at the time of Accurate, with the exception of a few jurisdictions, including Washington. As the court noted, that generally did relate back, subject to an exception that the court found existed here, but which didn't exist, but was essentially wiped out by the amendment to the statute. The other point, I think the court inquired of Mr. Dewig regarding regarding the reliance in the exception, what sort of reliance on the exception, what sort of reliance was required as a result of the exception. And I think the statute requires specific reliance because not general reliance, because it says that it carries on the affairs except for the rights of a person arising out of an act or omission in reliance, which means that the act itself must have been taken in reliance on the dissolution before the person knew or had reason to believe reason to know of the reinstatement. So I don't think that you can just talk about the fact that here where the deed wasn't recorded, that can't be construed as a reliance on the dissolution, because that had nothing to do with reliance on the dissolution. Those are the points I wanted to make at this point, unless the court has additional questions.
All right. Thank you. I'd like to thank both counsel for your briefs and arguments today and for your patience with some of the technological glitches we've been experiencing. So your case is submitted and will be taken under advisement.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you. And counsel, you can go ahead and exit out of the Zoom link, and we'll bring in the counsel for our next case.
Thank you.
Bringing in the next case.
All right. Good morning, counsel, and thank you for your patience. We're a little delayed today due to some technological glitches. I see Attorney Warren is connecting. Can you hear us, Attorney Warren? All right. Good morning, Attorney Warren. Can you hear us? Attorney Warren, are you able to hear us? Attorney Warren, are you able to hear us? I don't know if there's a way our courtroom clerk, Mr. Green, can assist Mr. Warren. Can you hear us now, Mr. Warren?
Yes.
Oh,
Can you hear me?
great. Yes, we can. All right, counsel, thank you all for your patience today. We've had a couple of technological glitches, a little bit delayed. This is our third and final case this morning. Closet Title Services Incorporated, doing business as Federal and Escrow Company et al. Versus Michael Nadel. And we have two consolidated matters before us today. I guess I'd like to start by clarifying how counsel wished to divide the time this morning. We can't hear you, Mr. Warren. You're on mute. I'm sorry. Mr. Warren?
He seems to be frozen. Oh, okay, not now.
Ms. Evans, was there any preference as to how we divide the time this morning?
Your Honor, I was prepared to talk about both cases together, the second one being primarily about attorney's fees, which is a smaller issue that will mostly rely on our briefs. I apologize for not responding. I thought you were asking how the appellees would like to divide their shared time.
Yes, Mr. Carey and Mr. Warren, how would you like to divide your time today for argument?
Your Honor, I will go first, and I will take approximately 12 minutes, and Mr. Carey will follow me and take 3.
All right, thank you. All right, Ms. Evans, are you ready to proceed?
Yes, Your Honor. Thank you. Stacey Evans on behalf of the appellant, and I would like to reserve 4 minutes for rebuttal.
All right, thank you.
May it please the court, this case involves a private real estate closing that went horribly wrong. The appellees fell victim to a hack and wired money that was meant to close on a new home to a thief. But they accused the appellants, their closing attorney and escrow agent, of stealing their money. The appellants sought a retraction but never got one. And after a year, they filed a lawsuit so that the 1-year statute of limitations that applies to defamation claims would not run on them. Instead of defending this very private matter on the merits, the appellees claimed that this case involved a public controversy and moved to dismiss the case as a strategic lawsuit against their public participation, otherwise known as a SLAPP statute. Now, to enjoy the benefit of the anti-SLAPP statute that the district has, a defendant must make a prima facie showing that their case involves claims that do arise from an act in furtherance of the right of advocacy on an issue of public interest. If a defendant does that, however, it doesn't mean the case is over. It just means that the plaintiff must show a likelihood of success on the merits, which this court has interpreted as a probability standard, specifically whether a jury properly instructed could reasonably find that a claim is supported in light of the evidence presented or proffered. This case is not a SLAPP, but even if it was, the appellants met the burden to survive the special motion to dismiss. The trial court erred in finding that this was a SLAPP case when it held that the statements at issue in this case were about the public issue of cybercrime. They were not about cybercrime, and in fact, the speaker, Mr. Nadell, denied that there was ever a hack at all, which means they couldn't have been about cybercrime. But certainly there was no debate about cybercrime. There was not one side advocating for cybercrime and another side advocating against, which was the kind of discussion.
But I thought the trial court also classified this as a SLAPP, anti-SLAPP case because of the judicial connection. Isn't there an exception within the statute where certain judicial controversies can be viewed within the lens or fall within one of the exceptions of this statute?
No, Your Honor, the trial court was not relying on that prong. It specifically talked about this issue involving the public interest issue of cybercrime. But even still, the prong that you're referring to does not actually allow any situation that happens to be in litigation in a court in the district to qualify for this special protection under the anti-SLAPP statute. To do so would be to read out the entire point of the statute, which is
but just
dialogue.
Talk a little bit about the scope of that judicial exception and what it would allow and why this case is different.
Your Honor, it would allow, sorry, siren. It would allow a case to come into the purview of the anti-SLAPP statute if it involved an issue of public interest. And not every case is of public interest. Just because it's of interest to the parties doesn't mean it's of interest to everyone. And it's very important to note that the language of the three things that can fall under the anti-SLAPP statute, the third one is sort of a catch-all, and it includes district government issues. If the prong that you're referring to included any litigation, any matter before a legislature, any matter before an executive branch, then that third catch-all prong would not need to include district government issues. And two other jurisdictions have looked at exactly the same language as the district's anti-SLAPP statute has. And in order to ensure that the anti-SLAPP statutes in those jurisdictions kept in line with the purpose of the statute, which was to protect public debate, they specifically declined to read that prong to include all litigation and talked about how you would be any.
No, I'm not suggesting that all litigation obviously would fall within the purview of the statute, but I'm asking you why this litigation doesn't.
Yes, Your Honor, because this is specifically a private dispute between two people about whether someone falsely accused Federal Title and Mr. Ewing of theft.
Well, but a lot of that may be one piece of it. There were elements of the cyber crime alleged here, and I understand your response to that. So it's not just because it's a litigation between private parties that remove it from the judicial exception, right?
Correct.
And if it were, if you agreed with the trial judge's finding that it was a cybersecurity issue that could bring this judicial litigation within the purview of the statute.
No, Your Honor, because the case was not about cybercrime.
No, I understand that's what your view is, but the trial judge found that it was, and if we agreed with that, then that would be enough to get it within the statute. I understand all the reasons you say that that would not be correct.
Right. If you did, Your Honor, if you agree that it was about cybercrime in the larger sense that the society could be affected by it, then I would actually say maybe, because the public, just because it might be newsworthy doesn't mean, and the public might want to know about it, it doesn't mean that they are actually, that it's actually an interest of public interest, because they have to also have the public at large, or a segment of the public has to have an interest in the outcome. And here, like I said, even if you assume it's about cybercrime, but again, the speaker denied that a hack even occurred, the public or some segment would have to have an interest. It's not like we're talking about gun rights or abortion rights or whether we're going to end cash bail and that would affect society at large. This case, the underlying case here, the defamation action, will only affect the parties that are involved in it. It won't have a larger effect on society. But even if Your Honors found that it would fall under this prong of interest, it would actually still be excluded from the anti-SLAPP statute here, because there is a general exclusion for statements that are made to promote someone's businesses. And Mr. Nadel was promoting his services as a lawyer when he went on the radio. And certainly when they posted those statements on McDermott, Will, and Emery's law website, which is meant to talk about their legal services to clients and potential clients, that was a commercial purpose that would fall under the exception under 165505, that regardless of whether the public might be interested in the case, if the speaker is talking about it to promote their services, then the anti-SLAPP statute says it doesn't apply nevertheless. So that is one of the biggest exceptions here. And at the very least, it applies to those website statements. But then there's still another reason that the anti-SLAPP statute wouldn't apply. And that is because specifically from the private interest definition is excluded statements that are made to protect someone's commercial interest. And when Mr. Nadel went on the radio on behalf of himself and his clients, he talked specifically about, we have to get our money back. So that is going to also cause this case to fall out of anti-SLAPP statute coverage. And then finally, the third reason that it doesn't apply, that the anti-SLAPP statute doesn't apply, is one we've been talking about generally, is that there is no public interest debate at play here, no debate about whether cybercrime is good or bad. And we weren't trying to end a debate when the defamation lawsuit was filed. And this court in Mann specifically said SLAPP statutes are those that are not meant to win cases. They're meant to silence debate. Here, there was no debate to silence on any issue of public interest, cybercrime or otherwise. But even if this
Ms.
court,
Go ahead. I'm sorry.
Your Honor. No, I was going to move to a new point.
I was just going to say that I believe our court issued an opinion just this morning in the Saudi American Public Relation Affairs Committee case that's cited in the briefs. And I don't know whether you had a chance to even realize that that opinion is out there. I wanted to give you an opportunity to say anything you care to say about it if you have seen it and read it. And if not, I don't know, I'll yield to the chief, but perhaps we'll allow an opportunity for some sort of supplemental briefing if you have not seen it. And I could well understand if you haven't.
Your Honor, I have not.
Well, the trial court was reversed, so that has some interest for you, I'm sure.
Yes.
Ms. Evans, this may be a far out of the field question, but you were emphasizing, of course, the private nature of this matter and going to say the anti-SLAPP statute doesn't apply. Does that at all limit your defamation claim?
No, Your Honor, because even if the court decides that this case falls within the purview of the anti-SLAPP statute, it doesn't mean that the case is over. And this court stated in Mann that the anti-SLAPP statute is not a sledgehammer meant to get rid of any claim against the defendant that's able to meet the prima facie showing that it falls under the statute. And
No, I understand that. I was thinking more in the concept of defamation. In this case, at least, it seems to me, at least, that Mr. Nadel was talking about communicating his theory of the case as opposed to some broader matter. And I just wondered if, your narrowing of it for anti-SLAPP purposes had any bearing on how you would articulate your argument on the defamation claim.
I'm not sure that I understand your question. If you're are you referring to the appellee's position that they're entitled to some fair report privilege?
No, why don't you just move on to it? I'll bring it up again if it hits my mind when you pursue the defamation claim.
I apologize, Your Honor.
No, I apologize to you. We should be clear with our questions. Go ahead.
No, I'm clearly missing something. I do apologize. But we have to move on to showing that we have a likelihood of success on the merits if this court were to find that the case falls under the anti-SLAPP statute. And we've done that. We just have to show that a reasonable jury could find that there was defamatory meaning here. And certainly that is true because the statements accuse Federal Title and Mr. Ewing of committing a crime. It's not subjective. It's not an opinion. They say either they stole the money or they caused it to be stolen. Either that happened or it didn't. It's true or it's false. It's not an opinion. Like, for example, if I called someone a jerk, which I wouldn't do because that's rude.
Well,
but that's
I take it we're moving on to defamation, and isn't it pretty clear that what the attorney, Mr. Nadel, was saying in response to a question from the WAMU reporter was basically his theory of the case? This is what is in the complaint. These are layperson's words I'm using. And yes, at one point he said that there was a question whether the defendant stole it. But in any event, it just strikes me that the level of odiousness and things that normally are required to show a defamatory outcome just aren't there in terms of what a reasonable hearer would hear when they heard or read that statement.
Well, the statement was made and is published in at least 3 different contexts: on the radio, in an article, which is not at issue here, and then on the McDermott, Will, and Emery website. And at least for the first and third, the listeners, the reader in the third case, they do not have the context that the article provides, because Mr. Nadel does not say, as we allege in our complaint, let me tell you about our complaint. He simply says that the.
Well, but wasn't it clear from all of these sources that he was talking about a complaint that had been filed?
No, Your Honor, the record doesn't support that.
No?
No, he said that our client stole something or caused something to be stolen. The only context that appellees have offered in this case is to talk about the article that the radio station published in writing afterwards. And we have no reason to assume that everyone that listened to the radio also read the article. And the law doesn't require us to do that, because just because there's an article about something that's not defamatory, doesn't carry a defamatory meaning, does not mean that there are not other publications of it that are. And here we submit that at the very least, the radio statements and the statements made for commercial purposes on McDermott, Will, and Emery's website were defamatory and were not under any privilege. For example, the fair report privilege is not meant to protect someone that repeats their own statements. And if you are going to take that protection, you have to attribute it to what you're talking about, which here would have been the complaint. That context has to be provided for readers, because the fair report privilege at its base is meant to protect the public and its right to have folks tell them information that's going on in official proceedings. But to get that privilege, you have to make sure that the listener knows that's where it's coming from. That's where the credibility comes from. I see that my time has expired.
Can I just ask you though, what targeted discovery you needed in this case? Because you, as you described, as you answered Judge Farron's question, you seem to suggest that it's almost open and shut, the facts about the statements and the context of them. What more did you need before the court could rule?
Your Honor, I believe that we have presented the evidence to show that this doesn't fall under the anti-SLAPP statute based on our arguments. But if there was any question about why Mr. Nadel was going on the radio, that the court was convinced made this not a commercial exception, then we would submit that we would need targeted discovery to show that purpose. And then with regard to the underlying defamation claim itself, again, we believe that Mr. Ewing's declaration and the other evidence in the record is sufficient for us to move beyond that likelihood of success probability standard. But if the court is convinced that, at least at this point, that the fair report privilege applies to Mr. Nadel's statement, then we submit that we are entitled to discovery on actual malice about whether Mr. Nadel was reckless or knew that those statements were false when he made them, because actual malice absolutely defeats a use of the fair report privilege. And that would be what we would submit we would need for discovery, but only if the court would apply the fair report privilege.
Excuse me, did you ask for any discovery?
Yes, we did, Your Honor.
And were you given an opportunity for discovery? Any, or just not as much as you had requested? I'm sorry.
We were not given the opportunity for any, Your Honor. And in fact, the trial judge ruled on this case believing that we hadn't even submitted a brief and the declaration that we did, and without holding the hearing that's required under the statute. And then only after we moved for reconsideration, pointing out these errors, did we have a hearing. And so at that point, the judge had already decided against us, and we were arguing, and certainly no opportunity was provided for us to take any discovery to disabuse the court of its findings.
But you did not ask for it.
We did, Your Honor.
In the rehearing as well?
In the papers, I don't want to say that we asked for it on the record in the hearing, because I would want to check the transcript, but I know in our papers, we submitted that this was something that we would need, and that we are entitled to under the anti-SLAPP statute, because of the court's continuing concern that it is cutting out the constitutional role of a jury and not allowing the development of evidence. And that was constitutional avoidance decision in Mann to make sure that the statute itself wasn't declared unconstitutional, that if there is evidence that would support a plaintiff's claim to continue, even in the face of an anti-SLAPP case, that they would be afforded targeted discovery so as not to trample on the Constitution.
Well, our court also had a recent decision earlier this year in Friedman v. Orbis Intelligence Limited that dealt with this whole issue of targeted discovery and indicating that the requester had to show good cause. And I don't know if that case was at issue or was issued at the time you were seeking the targeted discovery from the trial court or not.
Your Honor, it was decided after that, but even under that standard, we have shown that what we would be looking for and how it would affect the case. And so we believe that we would qualify under the standard that this court set in that case.
Right. All right. Any other questions for Ms. Evans before we hear from Mr. Warren? All right. Thank you, Ms. Evans.
Thank you.
Mr. Warren, you're on mute. We need you to unmute, please. Okay. Thank you.
Can you hear me, Your Honor?
Yes, we can. Thank you.
All right. Thank you. Roger Warren, appearing on behalf of the appellees, Michael Nadal and McDermott, Will, and Emery. I'd like to begin with the questions that Judge Farron asked, because it's very clear here that the defamation case was properly dismissed because the statements in context cannot be reasonably considered to be defamatory. If you look at the article, which is attached to the complaint, this is the WAMU article. The headline is "Hackers Allegedly Steal $1.5 Million from DC Couple in Home Buying Phishing Scheme." Mr. Nadal did not call the reporter for WAMU. The reporter called him. Why did the reporter call him? On a Monday, because 3 days earlier, the lawsuit had been filed. In looking at the statements, the only statements that the plaintiffs allege are defamatory by Mr. Nadal, it's critical to look at the sentence that precedes them. Let me read it to you. Last week, the couple filed a lawsuit against the company alleging that Federal Title either conspired to defraud them of $1.57 million or was so negligent in its online security protocols that it all but allowed the money to be stolen. So it is very clear in context that in responding to questions from a reporter who called him as a result of the lawsuit that had just been filed, Mr. Nadal, in answering, is paraphrasing the claims that were made in that lawsuit, that he was
Mr. Warren, Mr. Warren, excuse me, was that preface, the lawsuit preface, included in the website and the article, and importantly in the oral or the over-air communication by the radio station?
In the plaintiffs, they allege that the statements in the article and the statements online were the same. They don't make any distinction of that in their complaint. And we are unaware.
I'm talking about, wait a minute, excuse me. I'm talking about context. In other words, at least from my perspective, it's terribly important, or very important at least, that the hearer know the context that this is a lawsuit. Yeah, I just wondered if and I think I understood Ms. Evans to say that was not made clear over the air.
Well, that's not alleged in their complaint. And so far as we know, there's not a transcript of the interview. All we know is what the reporter chose to publish of the interview. But
was the audio played for the jury? The audio version of it
never went to the jury. It's not.
I'm sorry, for the judge. Did the judge hear the?
No, the judge didn't hear it. It's not attached as a link to the complaint. But what's interesting, in answer to Judge Farron's question, the actual lawsuit that was filed, the reporter from WAMU included a link to the complaint in the WAMU article. So if you were a member of the public and saw the online article and you wanted to actually see the complaint, you could click on it. The same with respect to the appearance on the McDermott website. The website simply clicks you to the WAMU article, and then you can click on the WAMU article, written article, to get to the actual complaint itself. And there's no reason to believe from reading the complaint that there's any difference between what happened in the broadcast and what happened when the reporter wrote it up and what happened when McDermott Will printed it on it, included a link on its website. There's no allegation that they are different. There's speculation that you see for the first time being raised on the Court of Appeals, but no reason to believe that the context was any different. And so unless there's some reason to believe that the context was different, judging the complaint where they treat them the same, it's very clear that what's being talked about is the lawsuit that was just filed 4 days before. Now, let's talk about and that would apply with respect to the fair reporting privilege as well, because the fair reporting privilege, which has been adopted by the District of Columbia, permits someone, even the author, and here Mr. Nadal drafted the complaint, to refer to what's in the public record, which is what he's doing. He's characterizing the lawsuit that he just filed 4 days earlier. Now, there's a suggestion that in their brief that he can't quote himself if he wrote the complaint. Well, that exception to the fair reporting privilege doesn't apply here. That exception only applies in circumstances where there are allegations or evidence that the original lawsuit was filed fraudulently, simply to permit the statement of a defamatory, the repeat of a defamatory statement. No allegation here at all, nor could there be. Mr. and Mrs. Smith lost $1.5 million. That's without dispute. And so what was being commented upon is how, and then a lawsuit was filed when Federal Title refused to reimburse them for that amount. A lawsuit was filed which sought to get their money back. If you look at the lawsuit, and I've got a copy of the complaint here in front of me, there are 8 separate counts. There's a conversion count where it says defendants' actions were proximately caused by the loss of 1.5.
Mr. Warren, Can I interject
Oh,
just
at any
briefly?
time. I speak too quickly. I'm sorry, Your Honor.
I wanted to ask about the false light claim that
Right.
I didn't, I'll ask Ms. Evans on rebuttal, but do you think that the trial court also erred in dismissing the false light claim and right along summarily, essentially, with the defamation claim?
No, actually, we don't think the trial judge erred in anything, because the false light claim would require, first of all, an underlying defamation of a false statement. And we just made it clear that there is not a false statement here. But more importantly, the statement would have to have been of or concerning Mr. Ewing. The false light claim against the company has been dismissed. So take a look at the article. Was there any statement? Take a look at Mr. Nadal's quoted statement. Was there any reference to Mr. Ewing? If you look at the article, Mr. Ewing is not mentioned at all in the 800 words of that article. If you look at Mr. Nadal's statement, he doesn't say Mr. Ewing stole the money. He just said the money was stolen. And the lawsuit, although it's against Mr. Ewing, it's against Ms. Shiflett, who was the one whose computer was hacked, that sent the emails directing them to pay to a different account. So the false light claim has to fail for the reasons the trial judge stated, which is there's no reference to Mr. Ewing in the underlying statement of Mr. Nadal or in the article that's on WAMU.
Thank you.
You're welcome, Your Honor. Unless there are more questions, either with respect to the fair reporting question, which I'd only started to get into, but if you look at the decision we cited from the Maryland Court of Appeals, highest court of Maryland, with respect to that privilege, which has been adopted in the District of Columbia by this court, the only question is, does it apply to a non-media defendant? The Maryland Court of Appeals makes it very clear that it does and should, because it's protecting a First Amendment right. I wanted to mention
before you move on, Mr. Warren, I just wanted to go back to your point about the on-air statements, because I was left thinking, maybe I misunderstood what you said. I was left thinking that the complaint didn't mention them, but I was recalling that it did. So now I have the complaint open and it does seem to. So can we just revisit that point? I perhaps misunderstood what you said. I thought I understood you to say that the complaint only talked about the website and the printed article.
No, Your Honor, and I hope I didn't misspeak, but I understand.
Well, I probably just misheard you. So what is your point about, the question you were answering was about context, I think, from Judge Farron, and whether a listener would have understood that a lawsuit was being referred to and described. And then the question was, well, what about the on-air statements? And what was your answer to that then?
The answer to that is the complaint, as you will see, it does allege on air, and in the published version, it alleges they were the same. So if you presume the defamatory statement, which they say is the same in all three publications, was the same, there's no reason to presume, nor is there an allegation that they were different. I mean, you simply can't bring a cause of action saying, well, we don't have the actual transcript, but we're speculating as to what it may or may not have said. When you file a complaint saying these are defamatory statements and these are the contexts in which they were stated, Mr. Nadal had no discretion over. This is unlike when a newspaper article or a book publisher is sued, where they have control of the context. He was interviewed by a reporter. Here, there's no reason to believe, nor do the plaintiffs allege, until they get to the Court of Appeals, that there's any difference between the on-air statement and the statement that was made in the printed version. And candidly,
okay, well, what they do in the complaint in paragraph 17 is to quote some language, which I guess is the language that they're alleging was defamatory. And I guess it's elsewhere in the complaint that they say that what was said on the air and what was said in the article were identical. I'm not seeing it right now, but
and that's our point.
All right, well, I'll revisit it and see what I see.
Yeah. They're alleging that the defamatory statements were the same, and they're alleging that what appeared on the air orally was the same as what was in the article. if that's true, what they're admitting is that the context is the same. And one of the things that was interesting at the trial court level, the trial judge asked counsel for federal title at that point. He said, look, it's very clear to me that the statements that Mr. Nadal made were referring to the lawsuit that was just filed. And keep in mind that the on-air version also took place 4 days after that. So there's reason to believe, and the complaint suggests that they were the same. But their trial court was asked the question, well, if Mr. Nadal had just said, we have alleged, or the complaint alleged, it would be non-defamatory. Why? Because he's characterizing what was filed in what was said in the recently filed lawsuit. This can't be the rule for defamation in this jurisdiction or any others, where you give talismanic effect to having a speaker who's talking to a reporter having to say the words, we allege, when it's clear from the questions from the reporter who's reporting about a recently filed lawsuit that it's defamatory if you don't say we allege, even though it's clear you're referring to the lawsuit, but it's not defamatory if you do say we allege.
All right, thank you.
And that was a point made by the trial judge as well, Your Honor. Could I move on, unless there are more questions on either false light or defamation, to a discussion of the anti-SLAPP statute? I think that to answer the question as to whether or not the trial judge correctly dismissed this case.
Mr. Warren, I'm sorry to interrupt you. We're still going to hear from Mr. Carey, correct?
That's correct. I've just been given 3 fingers indicating that of my 12 minutes, I've got 3 minutes left.
Okay, go ahead.
But that's by a colleague here in the room who's trying to keep track. On the anti-SLAPP statute, I think the beginning and the end as to whether or not the trial judge was correct is from a simple reading of the statute. The statute talks about the furtherance of a right of advocacy on issues of public interest. The reason WAMU called was because of the cyber hacking, an issue of public interest. That was what the headline was about in their article. So you read the statute next. Any written or oral statement made in connection with an issue under consideration or review by a judicial body. And then it talks about what is an issue of public interest. Public interest means an issue related to health or safety, environment, economy, community well-being. And it shall not be construed to be statements made primarily to protecting the speaker's commercial interests rather than commenting on or sharing information about public significance. Mr. Nadal did not initiate this call with the reporter to promote his services as a lawyer. The reporter called him. So the commercial interest exception clearly does not apply because that wasn't the principal purpose of his statements. And reading the act, it's very clear that cyber hacking was an issue that was of public interest, so acknowledged by the federal title spokesperson in the article itself. And you can see the quotes if you pull up the article, which is in the appendix, or you pull it up from our brief. They acknowledge that this is a matter of public interest. In fact, the reporter pointed out that the Federal Trade Commission and the Real Estate Association, before this took place, had sent out warnings to title companies about just this kind of thing happening. So there's no question that the issue of cyber hacking of real estate closing offices was an issue of public interest. And so once we're in the loop of the anti-slapping statute and have avoided this argument, which I think borders on inconsequential, that Mr. Nadal was trying to advance his own commercial purposes, we're then into whether or not there's a substantial likelihood of prevailing. So it's a different standard than 12b-6 on the defamation standard. It's a higher standard than you would have for plain defamation. But since we believe they don't even meet the lower standard with respect to dismissals under the defamation statute, they certainly don't meet the higher standard with respect to the anti-slapping law. Now, I'd like to make one last comment, and then I'll turn it over to Mr. Carey. I have not read the Saudi case, but my colleague in the room here is very industrious, and so he's been out and pulled it. And I understand there was a ruling that, contrary to what you've heard from Federal Titles Council here, discovery is not mandatory in these anti-SLAPP cases. It's discretionary, and in that case, the court found that it was not required. And we don't think it was required here because they've made all their allegations that are sufficient for the court to decide whether or not discovery is appropriate. And as this court has ruled on many occasions, the rules of the discretion to the trial judge with respect to what discovery is allowed or whether discovery is allowed are well established in this jurisdiction. Unless there are further questions of me, I will turn it over to Mr. Carey at this point. Thank you very much.
Mr. Warren, I have one more question, and that's in interpreting this 5502B, which says, quote, "The claim at issue arises under the Act in furtherance of the right of advocacy on issues of public interest." That's the governing principle under which you decide whether this is an anti-SLAPP statute case or not, right?
Yes.
Okay. Let's begin. The claim at issue, is that the suit by the title company? I mean, I'm having a hard time just...
No, it's a hard statute to read, and I've had to read it a number of times, Your Honor, so I appreciate your trying to sort through it. And it's relatively new in the District of Columbia. There's not a lot of DC law on it. It's only been here for 8 years. But the claim includes any civil lawsuit, claim, complaint, or cause of action, or claim. So the claim is a civil lawsuit. What's the civil lawsuit?
All right, so that's title company's lawsuit.
Yes. No, it's our claim. Okay, yes, it's the title company's lawsuit, which involves an issue of cyber hacking. But the claim underneath, see, in many cases, there aren't two lawsuits. So here, the claim that precipitated the press reporting was a claim that included a claim of cyber hacking. So that definition should be applied to Mr. Smith and Ms. Rona's claim against the title company. That claim was a claim of a matter of public interest because it explicitly refers to cyber hacking. And so that's the claim we're talking about. The retaliation is that the claim against the law firm and against Ms. Smith and Ms. Rona was the retaliation for having filed that claim in the first place. So this lawsuit was filed after the lawsuit was filed against District Title. Interestingly enough, at the time we were before the trial court, that other lawsuit, the lawsuit by Mr. Smith and Ms. Rona, was pending. It has since been settled.
Thank you.
All right.
You're welcome.
Thank you, Mr. Warren. Mr. Carey?
Good afternoon, Your Honors. I understand that you're being liberal with the time. I'll try to be brief. May it please the court. I'd like to start with the context, particularly with the article. I understand from Ms. Evans' comments earlier that that she doesn't include the article as the primary gravamen of the underlying complaint. But that's different from what the complaint says. We're having trouble putting our fingers on where they talked about on air, but it's in paragraph 17 of the complaint. And I think for purposes of the case before the court, we have to assume that whatever is written in the article was said on air, because there's nothing else in the record we can rely on. But in
That's
thinking
kind of
about
a big assumption, though, isn't it? I mean, rarely would an interview on the radio track word for word, I would think, a print article. I mean, I say that not with reference to this in particular, but I just find that kind of a huge leap to make. So I was looking to see where it is in the complaint that it was said that what was said on air was the same as in the article. And maybe that's not where that was said. If it was said, I didn't see it. I searched for the word same and I didn't find that statement. Where
Yeah,
was that said?
I understand you're on. The only place that I have found it is in paragraph 17 when they claim that Mr. Nadell's statements were verbatim on air and in the article. But I do think
Well,
that's
I
a
read
fault
that
of the
as there
complaint.
were some verbatim statements, and I can see that, but what's quoted does not have the context about the lawsuit. And as I said, I would just find it surprising that the text of a on-air interview tracks entirely an article. That would be a pretty boring on-air interview, I would think. Not the kind of thing people would listen to.
Well, if that's true, Your Honor, we can just look at the article as the gist of the complaint. And if we look at the context of the article, we have not only the linked lawsuit and mention of the lawsuit within the text of the article, but we have a level playing field. I did some counting of the words. The article is about 850 words, and the quotations attributed to Mr. Nadell are about 10% of the article, and the quotations attributed to Federal Title's spokesperson denying the claims are a little more than 10% of the article. So as far as having a level playing field to assert and deny the claims, which is a First Amendment concern, I think the playing field here was level, and that's the context that the court has to take the case in. But further to that, this court has said that the context has to be taken in terms of the standard of how an average mind would naturally understand them. And in thinking over the record, I asked myself, where can we look to find that? And I found it in the headline of the article, because Mr. Austermuhl, who authored the article for WAMU, either wrote his own headline or he submitted his copy to WAMU and they published it, and somebody else was in charge of writing the headline. And that headline says, hackers allegedly steal 1.5 million from DC couple in home buying phishing scheme. And that's the construction that the appellants have said is permissible. That's the first person who had to distill the article and make it into a headline took away from the article a construction that even appellants say is a permissible and non-defamatory construction. And going to Judge Farron's point, I do think the text of the statute is important here and has caused some of the issue on appeal. But before looking at 165502, I'm going to look at the definitions in 165501, section 1. And the definition there is the phrase, act in furtherance of the right of advocacy on issues of public interest, a defined phrase. And it has two subparts. And I think the court has already apprised itself of this. But part one, which is disjunctive from part two, is any written or oral statement made in connection with an issue under consideration or review by, including a judicial body. And that we had, in that there was an underlying lawsuit pending in the federal court concerning my client's effort at recovering money.
But don't you have to begin with sub 3 to get to sub 1? In other words, you're reading sub 1, as I recall, and but it has to meet the test of sub 3 before you get to the specifics of sub 1. Isn't that right?
Your Honor, these two phrases were defined separately, and I think the parties have struggled on how those fit together. But even if you look at sub 3, it differentiates using the private public distinction. It says that even a private interest or a commercial interest is not commenting on or sharing information about a matter of public significance. And as we've discussed, the WAMU reporter who spotted this case thought it had significant public interest. And I think it's similar to the cases that were also presented with anti-SLAPP motions, where you had, in the Mann case, climate change, or in the Tavis Smiley case involving sexual harassment.
Well, excuse me. I'm just suggesting that if it doesn't fall within sub 3, you don't get the sub 1. Isn't that an advantage to you?
Yeah, I'm not sure I follow you, but I think in both cases it works for us. Although I think that by the text of the statute defining act in furtherance of the right of advocacy on issues of public interest means, and then any written or oral statement made in connection with, the statutory text actually doesn't come back to an issue of public interest until you get to subpart 1A2. But I think we have both in this case, because once you had commenting about the underlying federal case, you also had a lawyer commenting to a member of the media who had interest in the case because of the fact that it dealt with a huge financial loss. It dealt with a hacking incident. It contains references to the fact that hacking has become pervasive. It references the story of John Podesta, whose email was hacked and whose email became a huge political issue in the last presidential campaign. So these.
Well, excuse me. I think I misspoke in the sense that you have to get by sub 3 in order to reach sub 1, as I understand it, and so I guess sub 3 from the SLAPP point of view is more difficult than sub 1. But anyway, I think we know what we're addressing.
Your Honor, I agree that the text of the statute is, it's divided in sub 1 and sub 3, but this is the definitional section of the statute, and both phrases are used at different times. Once you get over to 165502, it's referencing an act in furtherance of the right of advocacy on issues of a public interest, and so that's your first definition in the statute. And so you haven't even gotten down to issue of public interest, and whether the two phrases in the statute have any interplay with each other is not all that clear to me. I think there are probably, I could overstate that. There are obviously constraints on how far the First Amendment can protect you, but I think in our case, under the definition in 165501 1A1, both 1A1 and 1A2 apply in this case, and so the application of the anti-SLAPP statute is clear. The other point I wanted to make about subsection 1A1 is that the principles underlying comments made in connection with a judicial proceeding are the same principles that underlie the judicial privilege that gives immunity to an attorney from defamation while prosecuting or defending a case. And I think both principles apply here. And then in the case of the judicial privilege, this court has said that an attorney really needs to be given the utmost freedom in their efforts to secure justice for their client. And in this case, Mr. Nadel was prosecuting a case on behalf of now my clients, where they lost a significant sum of money due to a hacking scheme. And the crux of that underlying case was who is going to be responsible for that problem, and that theft. And I think given the way that Mr. Nadel couched his statements as if then, or either or, I think as a matter of logic and law, those can't be parsed down to smaller statements that I hear appellants making, and that the accusation was just that we stole their money. And just to sum up on a few points, I think the discovery point, I just wanted to point out that there's been a shift on appeal about what the target of the discovery was. In the trial court, the plaintiffs there requested discovery to get behind my client's ratification of their attorney's conduct. And that, that was intended to get behind the my clients are named defendants because of what their attorney said, and it's a theory of vicarious liability. The court below addressed that implicitly, in dismissing the case against Mr. Nadel. It had to follow that the case should be dismissed as to Mr. Smith and Ms. Rona. But this court has said that in the Friedman case that we've referenced, that the standard is for obtaining discovery is very difficult to meet, and that discovery shouldn't ordinarily not be permitted. And so I don't think there was any abuse of discretion by the trial court about discovery. And finally, I just want to mention the point on the second appeal is really procedural. It has to do with the fee orders under the Anti-SLAPP Act. Our point there is that our fee order was not timely appealed, and there's a jurisdictional problem there. If the judgment below were reversed, I think appellants would have a remedy under Rule 60B. But our assertion there is that the appeal is untimely as to the order for fees given to Mr. Smith and Ms. Rona. And so we'd ask that the court affirm the judgment of the court below and remand the case for additional fee proceedings. Thank you.
All right. Thank you, Mr. Carey. And I'd like to thank all counsel, Ms. Evans, Mr. Warren, and Mr. Carey for your arguments and your briefs today. We'll take this matter under consideration, and we stand adjourned at this time.
Your Honor.
Oh, did I forget
Evans
your
rebuttal?
Miss Evans? I'm so sorry.
Okay.
I'm so sorry.
It's been a long day, Your Honor.
It has been a long morning. My apologies. You reserved time for rebuttal, and I believe you reserved 3 minutes for rebuttal, and we'll give you your rebuttal time. Again, my apologies. Sorry about that.
It's okay. Thank you, Your Honor. I want to start by talking about an issue that was discussed a lot, which is context. It's important to understand that context only comes into play if we're going to consider some privilege that attached to the defamatory statements and made them okay to be said, even though they were false. And that would be the litigation privilege, which primarily applies just inside the courtroom. And then also the fair report privilege, which is what we've talked about a lot today. Those are privileges in the form of defenses for the defendants to raise. It is their burden to show this court that there was some context that would make otherwise defamatory statements allowable under the law. So it was not our burden to talk about that context. We don't think that the statements on the radio or the statements on the McDermott, Will, and Emery website had that we believe that those statements were defamatory and those statements were the same. If defendants want to raise a privilege, that is their burden to provide that context. And there is no context that has been presented in this record for the radio statements or the website statements. There's been a lot of talk about the context in the article, but again, the author of that article is not a defendant here. So the full context of that article is of no moment. Now, we also spent some time talking about the false light claim, and I wanted to—
Well, wait a minute, Ms. Evans. Let's take it a step further than the facts here, just to be sure I understand. If the reporter from WAMU put the microphone in front of Mr. Nadel and said, "Now I understand that you're involved in this big lawsuit, and what I want you to do is comment on the lawsuit so we know exactly what is going on in this thing." And he answers the same way he did now. Would you still be making the same argument?
It depends on what the response is. We don't have any—
Same response. I'm just trying to set up as explicit a predicate for that response that would create a context for telling the hearer that this guy is talking about a lawsuit. I'm stretching the facts, to a point where I'm trying to press you on what you just said, namely that there has to be some privilege that would be used to rebut a prima facie case of defamation. I mean, I just want to get your answer to that.
If it was clear that the speaker was talking about information in a lawsuit and that those were allegations that had not been proven, that the speaker was not speaking from his own personal knowledge or his own personal research, but he was saying, this is alleged in the
No, he was speaking as the lawyer who has prepared the complaint. I'll go that far. So it's not his personal knowledge, it's what his client has told him.
Right. If in fact he is being asked very specifically about what's in his complaint and he responds, then yes. But I want to caution that if, for example, I'm asked about so-and-so stole something from someone, and I say, well, yes, I've alleged that in a complaint. That's my responsibility as the speaker to make sure that if I'm going to take advantage of the privileges that are afforded to me under either the fair report privilege or the litigation privilege, I have to make sure that I do what is required to meet those standards. And here, that responsibility to provide that context would have been on defendants at the moment, and then certainly in this court proceeding to provide information on the record as to why otherwise defamatory statements were privileged to be stated. There are very specific exceptions in the law, and their standards have to be met, just as we would have to meet the standards for the claims that we are addressing. I wanted to address, I see my time has expired, but if it's okay for one point, Your Honors. There's talk of all the lawsuits here. There is the underlying lawsuit of the appellees suing Federal Title and Mr. Ewing to get their $1.5 million that they alleged my client stole. In the context of that lawsuit, they're saying there was no hack. They're saying we stole it, and that's what they went on the radio to talk about. We filed a lawsuit for defamation. That is the only lawsuit that should be considered in deciding whether this is a claim that falls under the anti-SLAPP statute or not, because that is the complaint that they are alleging was a slap at them, a slap to stop them from their public participation. So their original lawsuits against our clients should not be considered with regard to whether the complaint that they are attempting to slap is indeed a slap. And I appreciate Your Honor's indulgence with me on the time. Thank you.
All right. Thank you, Ms. Evans. And again, thank all parties for your briefs and arguments this morning and for your patience. And this matter will be taken under advisement. At this time, we stand adjourned.
Thank you.
Court is now adjourned.
All right. And counsel, you can feel free to sign out, log off.